Before we begin, a quick and important disclaimer. The following discussion regarding Islamic divorce or Khul'a and Talaq, within the context of the United States legal system, is provided strictly for educational and informational purposes only. This content does not constitute legal, religious, or marital advice. Divorce is a complex issue involving both intricate religious jurisprudence and binding secular law. Every state in the U.S. has different statutes governing civil marriage and divorce, and Islamic schools of thought regarding marriage contracts vary significantly. We strongly advise all viewers to consult with qualified family law attorneys and recognized religious scholars to address their specific circumstances. Please conduct your own due diligence before making decisions regarding your marital status or legal rights. Imagine standing in a courtroom in a bustling American city, perhaps in Texas, New York, or California. You are holding a marriage certificate, a document that binds you under both civil law and religious tradition. Suddenly, that bond begins to fray. You find yourself navigating two entirely different legal universes simultaneously. One universe speaks the language of state statutes, community property, and alimony. The other speaks the language of fiqh, mar, and the spiritual sanctity of a broken covenant. This is the reality for thousands of American Muslims today. The central tension here is not just about the dissolution of a relationship. It is about the collision of two systems that were never designed to intersect. Why is it that a couple can be considered divorced by their mosque, but remain legally tethered under the laws of their state? Or worse, why do some individuals find themselves trapped in a limbo where they cannot remarry, cannot access their assets, and are caught in a cycle of emotional and financial exhaustion? In this deep dive masterclass, we are going to dissect the academic and practical realities of divorce in Islam within the American landscape. This is part 1 of our 10-part series. Today, we are not just skimming the surface. We are mapping the terrain of a crisis that is often whispered about in community halls but rarely analyzed with the rigor it demands. We will explore the friction between civil secular law and religious obligation, providing you with the necessary framework to understand how academic researchers, legal scholars, and community leaders are attempting to reconcile these disparate worlds. The problem for the American Muslim population is profound. When a Muslim couple enters into a marriage in the United States, they are essentially signing two contracts. The first is the civil marriage license, recognized by the state, which grants them tax benefits, hospital visitation rights, and legal protections. The second is the nikah, the religious contract, which often includes a mar, or a dower promised to the bride. When the marriage fails, these two contracts often diverge. In the United States, civil divorce is straightforward in procedure, if not always in outcome. You file a petition, serve the spouse, and proceed through mediation or litigation. However, a civil divorce, in the eyes of many traditional interpretations of Islamic law, does not automatically dissolve the religious marriage. This creates a state of limping marriage, a legal term used to describe a marriage that is dissolved in one jurisdiction but persists in another. For the wife, this can be catastrophic. If she receives a civil divorce but cannot secure an Islamic divorce, she is effectively unable to remarry within her faith tradition. She remains bound to a man who may have abandoned the relationship, and she may lose the right to claim the remainder of her mar. For the husband, the issues are different but equally complex, involving potential claims to assets that might be governed differently by Islamic inheritance or contract law than by state community property laws. Consider the case studies emerging from sociology departments at major universities. Researchers are finding that the lack of synchronization between civil courts and Islamic councils leads to an increase in long-term trauma and financial instability, particularly for women. When the religious community fails to provide a mechanism for divorce that aligns with the realities of modern American life, the institution of marriage itself begins to lose its perceived legitimacy among younger generations. We see a growing trend where couples are increasingly skeptical of entering into formal religious contracts, fearing the legal and social entrapment that follows should the marriage sour. This series exists to solve the ambiguity surrounding this topic. We are moving beyond the anecdotes and the fear-based narratives. Instead, we are looking at the empirical data. We are looking at how American family law courts are increasingly encountering cases where Islamic divorce clauses in prenuptial agreements are being brought to the bench. We will examine how judges are wrestling with the First Amendment implications of enforcing, or refusing to enforce, religious divorce stipulations. Can a judge force a husband to grant a talaq? Does that infringe on his religious freedom? Conversely, Does refusing to enforce a religious contract deprive a citizen of their constitutional right to the free exercise of their faith? These are not merely abstract academic questions. They are the questions that define the day-to-day lives of real people navigating separation. Throughout this series, we will unpack the terminology of Islamic family law, including the distinction between talaq, which is the husband's right to initiate divorce, and khul'a, which is the wife's ability to initiate divorce through a return of the mahr. We will also examine the evolution of the role of the imam and the Islamic center in the United States. Historically, the mosque acted as a community mediator. Today, as the community grows more diverse and more integrated into the American professional class, the role of the imam is being challenged by the necessity of legal mediation and specialized arbitration. We are going to bridge the gap between religious theory and American practice. By the end of this 10-part masterclass, you will understand the historical trends that led to the current state of affairs, the legal frameworks that govern modern divorce, and the innovative solutions that some communities are piloting to create a more equitable process. You will learn about the rise of specialized arbitration councils and the increasing importance of robust, legally conscious marriage contracts. We are stripping away the myths and the cultural baggage to look at the cold, hard facts of legal reality and religious ethics. Whether you are a student of law, a member of the Muslim community, or someone simply interested in how diverse cultural traditions adapt to the American constitutional experiment, this series will provide the depth you have been looking for. We are not here to tell you what to do. We are here to ensure that if you ever find yourself in the position of needing to navigate this process, you are equipped with the knowledge, the vocabulary, and the understanding of the historical and academic landscape that shapes your options. The intersection of faith and the law is perhaps the most critical frontier for the American Muslim experience in the 21st century. It is time we examined it with the nuance it deserves. Stay with us as we embark on this detailed investigation, beginning with the foundations of the Islamic marriage contract in the American court system. To understand the modern dilemma of divorce, we first have to dissect the nature of the Islamic marriage contract itself, the nikah, and how it interacts with the United States legal framework in 2026. In the eyes of American civil law, a marriage is a contract between two consenting adults, regulated by the state, which grants specific rights and imposes specific obligations regarding property, child custody, and debt. The nikah, however, is a religious contract that creates a spiritual and moral union. When these two entities occupy the same space, they often operate on entirely different logical planes. Imagine a couple in 2026. Let us call them Sarah and Ahmed, who live in suburban Chicago. They sign their marriage license at the county clerk's office. They then proceed to their local mosque to sign their nikah contract. In that contract, they specify a mahr, a dower that acts as a financial safeguard for the bride. In many traditions, this mahr is divided into two parts: a prompt portion, paid at the time of the wedding, and a deferred portion, to be paid in the event of divorce or the death of the husband. This is the first point of friction. Under American law, a prenuptial agreement that addresses property distribution is subject to stringent judicial review. Courts often ask if the agreement was signed voluntarily, if there was full financial disclosure, and if the terms are unconscionable. When Sarah and Ahmed face marital discord and decide to separate, the secular divorce court sees a pool of marital assets. The state judge does not care about the religious mahr, unless it has been explicitly incorporated into a civil prenuptial agreement. If the mahr is simply a line in a religious document, it is often viewed by a secular court as an unenforceable religious promise, or at best, an ambiguous contract. This creates a massive void where the wife may be left without the financial protection the religious contract intended to provide, simply because the secular system does not speak the language of religious dower. Consider the historical trends observed by legal scholars over the last 2 decades. We have seen an increasing number of cases reaching appellate courts where one party attempts to enforce a religious divorce clause as a civil contract. These are known as get-like cases, borrowing from the Jewish tradition of the get, but the legal hurdles are remarkably similar. In these cases, one spouse argues that the other, by signing a religious contract, agreed to cooperate in obtaining a religious divorce. When the husband refuses to grant the talaq, or the wife refuses to return the mahr to facilitate a khul'a, the other party petitions the court to compel performance based on the contractual agreement. The courts are consistently hesitant here. The Establishment Clause of the First Amendment makes judges terrified of interfering with religious practice. A judge might rule that forcing a spouse to perform a religious act is a violation of their religious freedom. Consequently, you have individuals trapped. They are legally divorced by the state of Illinois, but spiritually and socially tethered to a previous partner because they cannot obtain the religious dissolution required to remarry within their community. This is not just a paperwork issue. It is a profound disruption of the social and psychological lives of those involved. What we are seeing now is a shift toward a more proactive approach. Couples are becoming more sophisticated. In 2026, we see a rise in the use of what are sometimes called Islamic-compliant prenuptial agreements. These are legal documents drafted by attorneys who understand both civil family law and Islamic jurisprudence. They explicitly define the mahr, provide for mediation through an Islamic arbitration council, and state that the arbitration award can be incorporated into a civil court order. This is a crucial distinction. It moves the religious obligation from the realm of the unenforceable into the realm of the legally binding. Think of it like this. Instead of relying on the good faith of a spouse during a messy separation, the couple is creating a roadmap for how they want their disputes to be resolved years before they ever actually occur. This allows the secular court to view the agreement not as an attempt to enforce religious dogma, but as a voluntary settlement agreement between two parties. The court is not enforcing Islam. It is enforcing a contract that the parties themselves negotiated. However, even this is not a panacea. The quality of these arbitration councils varies wildly. Some operate with transparency, utilizing both legal and religious experts to ensure fairness and compliance with both systems. Others may lack the procedural safeguards that American courts expect, such as the right to counsel, the right to present evidence, or the right to appeal. If an arbitration council issues a ruling that is patently unfair or ignores basic due process, an American court will likely strike it down, regardless of how religious it claims to be. The academic perspective here is clear. The integration of Islamic marriage and divorce practices into the American landscape is not an attempt to replace secular law with Sharia, but rather a process of harmonization. It is an exercise in pluralism. The question is how to protect the individual rights of those within the community while respecting the autonomy of the religious institutions. We have to consider the power dynamics at play. Often, the party who holds the leverage is the one who benefits from the status quo. If a husband is satisfied with a civil divorce but refuses to grant the religious talaq, he maintains a form of control over his former wife. In cases like this, the academic focus shifts to the role of the community centers. Should the imam be an arbitrator? Does he have the training to handle the complex financial and domestic issues that define modern American divorce? The consensus is increasingly that the imam must function in tandem with legal professionals. Relying on an untrained cleric to resolve multimillion-dollar asset disputes or custody battles is a recipe for disaster. What we are seeing is an evolving ecosystem. Some major cities are seeing the birth of formal, state-recognized arbitration panels that handle these cases with the seriousness of a legal proceeding. These panels include family lawyers, therapists, and religious scholars. They provide a space where the religious needs of the couple are met while ensuring that the outcomes remain within the bounds of civil legality. This is the future of the discourse. But for this to work, the community must be willing to sacrifice the informal, closed-door processes of the past in favor of the transparency required by modern life. The friction is real, and the consequences for failing to navigate it correctly are significant. When we talk about these case studies, we are not talking about hypothetical scenarios. We are talking about the loss of assets, the inability to remarry, and the long-term psychological impact on families and children. The next phase of our investigation will move away from the marriage contract and into the specific, often misunderstood mechanisms of the divorce process itself. We will break down the mechanics of the talaq and the khul'a, and we will examine why, in the American context, these two processes are far more complicated than they appear on the surface. We will look at how the lack of a centralized authority creates a vacuum that is being filled by a patchwork of solutions that vary from city to city and from mosque to mosque. You need to understand how the definition of a divorce is being fought over in the courts, and why this fight is the most important legal development for the Muslim community in this decade. The mechanics of divorce in Islamic tradition are built upon a foundation of specific terminology, yet when these terms are transplanted into the 2026 American legal landscape, they undergo a profound transformation. To understand why this is a point of constant litigation, we must look at the specific structures of talaq and khul'a. Talaq is the mechanism by which a husband can initiate the dissolution of the marriage. Khul'a is the process by which a wife can secure a release from the marriage, often contingent upon the return of her mahr or dower. Imagine a scenario in a family court in Michigan. A husband, let us call him Malik, informs his wife Amira that he is pronouncing talaq. In a purely traditional setting, this might be viewed as an immediate severance of the marriage bond. However, in the United States, that verbal pronouncement has zero legal weight in the eyes of the state. The state requires a court order, a decree of dissolution of marriage, signed by a judge. The mismatch here is the source of endless confusion. Malik may believe he has fulfilled his religious obligation, but if he fails to file the necessary paperwork with the county, he remains legally married. Conversely, if he files for civil divorce but refuses to provide the final religious declaration, Amira remains in a state of religious limbo. This leads us to the critical concept of the waiting period, or iddah. In Islamic law, the iddah is a period of time, usually 3 menstrual cycles or the duration of a pregnancy, during which the parties are to remain in a state of contemplation, potentially allowing for reconciliation. American divorce law, particularly in states with mandatory cooling-off periods, has its own version of this. But they do not align. A couple might be legally separated by the state, but religiously still be within the iddah, which complicates issues of child custody and support if the status of the marriage is in question. Academics point to the 2026 reality where these two systems create a phenomenon known as regulatory collision. When a family court judge oversees a case where a religious divorce is at play, they are forced to navigate the minefield of the First Amendment. If a judge grants a civil divorce while ignoring the religious requirements, they may inadvertently be signaling that the religious contract is irrelevant. If they attempt to incorporate the religious requirements into the final decree, they risk being accused of entanglement with religious practice. Consider a case study from a recent appellate court decision in New Jersey. A wife sought to enforce a clause in her nikah that required her husband to participate in a religious arbitration process to finalize their divorce. The husband argued that being forced to appear before an Islamic panel was a violation of his rights under the First Amendment, claiming it coerced him into participating in a religious practice he no longer wished to engage in. The court had to determine if this was a contract dispute, which they could adjudicate, or a religious dispute, which they had to avoid. The court ruled that if the clause was part of a contract that the parties had voluntarily signed, it could be treated as a private agreement. This is a massive shift in how the legal system views Islamic divorce. It is no longer just a private, hidden affair. It is increasingly being treated as a matter of contract law. The lack of a centralized authority for Islamic divorce in the United States means that this process is handled by a diverse, often fragmented, array of institutions. You have independent mosques, private Islamic arbitration councils, and even online services that claim to provide religious divorces. This decentralization is a major point of concern for sociologists. When there is no standard procedure, the potential for abuse increases. We see instances where a husband might shop around for an imam who will grant a quick talaq that favors his financial interests, while bypassing the protections intended for the wife. Or we see cases where a wife is denied a khul'a because the local council interprets the rules in a way that preserves the status quo of the marriage against her will. This brings us to the importance of the documentation of the marriage itself. Because the United States does not have a federal registry of marriages that accounts for religious requirements, the burden of proof rests entirely on the parties involved. If you do not have a robust, written agreement that details the process for dispute resolution, you are essentially at the mercy of whatever local religious authority you choose to approach. This is why we are seeing a push for more standardization in the drafting of marriage contracts. Lawyers who specialize in this field are now insisting that these contracts be as detailed as any business partnership agreement. They include clauses for arbitration, the appointment of neutral third-party mediators, and specific timelines for the completion of religious procedures that run parallel to the civil divorce process. The academic perspective is that we are witnessing the institutionalization of Islam within the American legal context. It is a slow, difficult process. The old guard might prefer the informal, community-led mediation that characterized the immigrant experience of the late 20th century. But the younger generation, which is highly educated, legally aware, and integrated into the American professional landscape, is demanding more certainty. They are not satisfied with the idea that their marital status depends on the whims of a local cleric. They want a system that is transparent, predictable, and fair. The struggle is not just about divorce. It is about identity. It is about what it means to be a Muslim living in a secular constitutional republic. Can you be fully committed to your faith and fully compliant with the laws of your state without feeling like you are compromising one for the other? The academic literature suggests that the answer is yes, but it requires a level of engagement with both legal and religious systems that has historically been lacking. As we move forward in this series, we will examine the specific role of the Islamic Arbitration Council. We will look at the rise of professional, legally trained arbitrators who are stepping in to fill the void. These individuals are attempting to create a new model of dispute resolution that is grounded in the tradition of Islamic law, but functions with the rigor of American civil procedure. They are the bridge builders, but their work is constantly challenged by the legal uncertainties we have discussed. The next phase of our investigation will delve into the challenges of enforcement. Even if you have a perfectly drafted contract and a fair arbitration award, how do you actually get a court to recognize it? What are the limits of judicial deference? And why is this the most volatile aspect of the intersection between religion and the state? The answers might surprise you and challenge your assumptions about the power of the law to provide a resolution in the most intimate of human affairs. The challenge of enforcement represents the final frontier in our analysis of Islamic divorce within the American legal system, as of 2026. You have a religious contract, perhaps even an arbitration award, but the moment that paper leaves the mosque and enters the state courthouse, the rules of engagement shift entirely. The central tension here involves the doctrine of judicial deference and the wall of separation between church and state. When a party attempts to bring a religious arbitration award before a secular judge to have it recognized as a court order, they are asking the state to put its seal of approval on a religious decision. Imagine a case involving a couple, let us call them David and Fatima, residing in a jurisdiction that is generally skeptical of private arbitration. They have undergone an Islamic arbitration process regarding the division of their assets, including a home and retirement accounts. The arbitration panel, composed of respected community elders and an attorney, has issued a detailed ruling. David, dissatisfied with the outcome regarding his pension, refuses to comply. Fatima then files a petition in the local family court, asking the judge to confirm the arbitration award. This is the moment of maximum legal volatility. The judge has to navigate the Federal Arbitration Act and the relevant state statutes. If the judge confirms the award, they are effectively enforcing a private religious process. If they refuse, the arbitration is rendered functionally toothless. The potential outcomes here depend heavily on the procedural integrity of the original process. Was there a clear written arbitration agreement signed by both parties at the outset of the marriage or at the time of the dispute? Did the parties have the opportunity to present their own evidence and cross-examine witnesses? Were the principles applied in the arbitration consistent with fundamental concepts of fairness, even if those principles were rooted in religious law? Historical trends in judicial intervention show that courts are increasingly willing to enforce religious arbitration awards, but only if they are framed as secular contracts. If the arbitration agreement is drafted in a way that looks like a standard commercial contract, with clear definitions of the scope of authority, the process of selection for the arbitrator, and the methods for dispute resolution, the court is significantly more likely to treat it with respect. The problem arises when the agreement is vague, relying entirely on the authority of the religious institution without grounding itself in the procedural language that American courts demand. We see a growing divide in legal strategy. On one side are practitioners who advocate for incorporating religious requirements into civil prenuptial or postnuptial agreements. This is often the most effective route because it provides the court with a clear, enforceable civil instrument. On the other side are those who rely on informal mediation, hoping that the moral authority of the religious community will be enough to ensure compliance. The academic data suggests that the latter approach is increasingly failing as the community becomes more integrated, more litigious, and more conscious of its civil rights. There is also the significant issue of the gendered nature of these disputes. Consider the complexity of custody disputes. This is where the tension between religious and secular law is at its peak. State law requires that all decisions regarding child custody be made based on the best interests of the child. Islamic law, depending on the school of thought, may have specific guidelines regarding the age and gender of children and their guardianship. The human cost of the collision between Islamic religious procedure and American civil law is best understood by looking at the concept of the limping marriage. Imagine a woman, let us call her Layla, living in 2026. After a turbulent 5-year marriage that ends in a civil divorce, Layla finds herself in a position where she is legally free to remarry under the laws of the United States. She has her divorce decree from the state court, and her finances have been settled through equitable distribution. Yet, her former husband refuses to cooperate with the religious process of issuing a talaq, or he makes the Khul'a process contingent upon her forfeiting her mahr or even paying an exorbitant sum of money back to him. For Layla, the consequence is not just spiritual. It is social, psychological, and practical. Because she cannot obtain a formal religious divorce, she remains, in the eyes of her community, a married woman. If she attempts to remarry in a mosque, she will be unable to find an imam willing to conduct the ceremony. She becomes a pariah in some social circles, labeled as someone who has abandoned her marital duties. This is a form of social entrapment that the secular legal system is largely blind to. The state sees a divorced person. The community sees a married one. The psychological toll of living in this double existence is immense, leading to chronic stress, anxiety, and a profound sense of alienation from the very community that should be providing her with support. When researchers study these cases, they identify a clear trend. Women are disproportionately affected by the refusal of husbands to facilitate a religious divorce. This is rooted in the traditional asymmetry of divorce rights, where the husband holds the unilateral right to talaq, while the wife must often seek the intervention of a panel or the consent of her husband for a khul'a. In the United States, this asymmetry is exacerbated by the lack of a centralized, enforceable Islamic authority. If a husband simply ignores the requests of his wife and the local imam, there is often no mechanism to compel him to act. He can effectively hold his former wife hostage to his will for years, or even decades. Consider the case studies of women who have spent over a decade trying to resolve their marital status. Some have resorted to public shaming within the community, while others have retreated from public life entirely. The impact on their children is equally severe. A mother who is in this state of limbo is often unable to provide a stable, traditional home environment that her community expects. We see a rise in depression and developmental issues in children who are caught in the middle of these protracted, unresolved separations. This is a silent crisis that is often ignored because it happens behind closed doors, hidden by the cultural stigma surrounding divorce in conservative communities. The academic data shows that this situation is changing as the younger, more educated generation of American Muslims begins to speak out. They are challenging the patriarchal interpretations that have dominated these discussions for generations. They are demanding that mosques and community centers adopt clear, transparent, and gender-equitable policies for handling divorce. They are insisting that the role of the imam be limited to religious guidance, and that professional legal and psychological mediators be brought in to handle the mechanics of the separation. This is not just a demand for better administration. It is a demand for justice. We have to understand that the refusal of a religious divorce is often used as a tool of financial coercion. A husband might refuse to grant a talaq unless the wife agrees to lower child support payments, relinquish her rights to marital property, or give up custody of the children. Because the wife is desperate to regain her status and move on with her life, she is often forced to agree to these lopsided terms. This is a form of domestic abuse that is facilitated by the gap between the religious and civil systems. It is a manipulation of the faith to achieve an outcome that is fundamentally at odds with the ethical principles of that same faith. The legal system is slowly beginning to recognize this. We are seeing more family court judges asking about the religious status of a marriage during divorce proceedings. Some states have even considered legislation that would prevent a party from finalizing a civil divorce if they are deliberately withholding a religious divorce that would enable the other party to remarry. While these laws are controversial and face significant constitutional hurdles, they demonstrate a growing awareness that this is a public problem, not just a private one. The goal is to create a pathway where the religious and civil processes move in tandem, rather than in conflict. This requires a fundamental change in how the community thinks about the marriage contract. The nikah needs to be treated with the same seriousness as a civil marriage license. This means including specific, legally enforceable clauses that define the process for divorce, the role of mediation, and the financial protections for both parties. It means moving away from the oral-based, informal traditions of the past and embracing a culture of documentation and transparency. It means ensuring that every woman who enters into a marriage is aware of her rights and has the tools to protect herself if the marriage fails. The academic community is currently advocating for a more robust model of arbitration that is grounded in the principles of equity and due process. This involves training imams and community leaders in the basics of American family law, conflict resolution, and the psychology of divorce. It involves creating a network of professionals who can work with families to navigate the complexities of their situation. This is a long-term project that requires the cooperation of religious institutions, legal professionals, and the community at large. The stakes could not be higher. If the community fails to address these issues, it risks alienating a significant portion of its members, particularly those who are already struggling to balance their faith with the realities of modern life. We are seeing a decline in the number of young people who are willing to enter into a traditional nikah, precisely because they fear the lack of protection it offers. The future of the institution of marriage within the American Muslim community depends on our ability to create a system that is just, equitable, and compatible with the legal framework of the United States. As we conclude this examination of the human cost, we must look at the institutional response. In our next session, we will investigate the rise of specialized Islamic arbitration councils and their impact on the legal landscape. We will look at how these councils are trying to bridge the gap between faith and law, and we will analyze the results of their efforts. You will learn about the challenges they face, the successes they have had, and why their existence is a testament to the resilience and adaptability of the American Muslim community. This will lead us into a deeper analysis of the potential for a national standard for Islamic divorce, and what that would mean for the future of the community. The rise of specialized Islamic arbitration councils in the United States represents the most significant structural change in the community's approach to divorce in 2026. For decades, the resolution of marital conflict was largely confined to the informal, decentralized network of local mosques. While this model offered a sense of community and cultural continuity, it frequently lacked the procedural rigor, transparency, and legal integration required to navigate the complexities of American family law. The new arbitration councils, by contrast, are attempting to formalize the process, often operating with a level of professional oversight that mirrors secular mediation services. Imagine a couple in 2026, let us call them Hisham and Nadia, residing in a major metropolitan area. When they decide to separate, they do not just approach their local imam. They turn to an established, state-recognized Islamic arbitration council. This council is comprised of a multidisciplinary team, including an attorney specializing in family law, a licensed therapist, and a recognized religious scholar. This is the crucial advancement. The attorney ensures that the process respects the procedural requirements of the state, such as documentation, notice, and the right to counsel. The therapist addresses the emotional and psychological dimensions of the separation, which are often the primary drivers of conflict. The scholar provides the religious guidance, ensuring that the final outcome aligns with the couple's faith-based obligations. The council's primary objective is to draft a comprehensive settlement agreement that addresses both the civil and religious aspects of the divorce. This agreement is then presented to the parties for their voluntary review and signature. Once signed, the council's work is framed in a way that allows it to be presented to a civil court judge for finalization. This is the bridge-building mechanism we discussed earlier. The judge, seeing a document that has been professionally vetted and signed by both parties, is much more likely to incorporate its terms into the final civil decree. This approach addresses several systemic issues. First, it eliminates the ambiguity of the limping marriage. By coordinating the Talaq or Khul'a with the civil divorce process, the couple ensures that their status is resolved in both realms simultaneously. Second, it reduces the risk of coercive outcomes. Because the process is overseen by a panel that includes legal professionals, there is a lower chance of one party successfully using religious leverage to extract unfair financial or custodial concessions. Third, it provides a sense of finality that is often absent in informal mediation. When a settlement is reached through this structured process, both parties are more likely to honor it because they understand that it carries both religious and legal weight. However, the creation of these councils is not without its challenges. The primary obstacle is the lack of a national standard. As of 2026, these councils operate independently, with different procedural rules, varying levels of expertise, and inconsistent results. What works in one state may not be applicable in another, given the diversity of family law statutes across the country. There is no central body that regulates these councils, no unified training program for their members, and no mechanism for holding them accountable if they fail to uphold the standards of fairness and due process. Researchers and legal scholars are currently examining the feasibility of establishing a national accreditation body for these councils. This would be a monumental step forward. Such a body could set uniform standards for practice, establish a code of ethics, and provide training for both religious and legal participants. It would create a level of accountability that is currently lacking. but the resistance is significant. There is a deep-seated suspicion of any central authority that might attempt to dictate how religious matters are handled. Many in the community worry that such a move would be a step toward the institutionalization of religious law, in a way that is antithetical to the American spirit of individual freedom and local autonomy. We must also consider the cost. Professional arbitration is not free. In many cases, the fees charged by these councils can be prohibitively expensive, effectively excluding those with fewer financial resources from accessing the very mechanism designed to ensure fairness. This creates a two-tiered system where those who can afford professional mediation get a structured, fair divorce, while those who cannot are left to navigate the informal, often unpredictable, and potentially abusive systems of the past. The data indicates that this is already a growing disparity, and it is one that the community must address if it is to provide a truly equitable service to all its members. Despite these challenges, the trajectory is clear. The trend is moving toward professionalization, transparency, and legal integration. The informal models are being exposed as inadequate for the demands of 2026. The shift toward specialized councils is a response to the failures of the past, and it is a testament to the community's ability to adapt and evolve. We are seeing a new generation of leaders, both religious and secular, who understand that the sustainability of the Muslim community in the United States depends on its ability to create a system that is robust, respected, and fair. The question of whether a national standard can be achieved is the ultimate test for this community. It requires a level of consensus that has yet to be reached. It requires the courage to challenge established traditions and to embrace new models of practice. It requires the recognition that religious adherence and legal compliance are not mutually exclusive, but rather two sides of the same coin. This journey toward a national standard is the most important development in the field of Islamic family law, and its success or failure will shape the lives of generations of American Muslims to come. As we continue this masterclass, we will shift our focus from the institutional to the aspirational. We have examined the problems, the mechanics, and the current attempts at solutions. Now, we will look at what a future fully integrated system might look like. We will explore the role of technology in automating and streamlining the process of divorce, and we will analyze how emerging models of conflict resolution are being adapted for the unique needs of the community. You need to see how the next decade will likely unfold, and why the decisions made by leaders today will have a profound impact on the legal landscape of tomorrow. We are moving from the reactive to the proactive, and you will see how the conversation is evolving to prioritize the long-term health and stability of the family unit above all else. The evolution of the American Muslim family landscape in 2026 is increasingly driven by a technological and proactive shift toward streamlined conflict resolution. We are observing the early stages of what can be called digital-first mediation, where the traditional face-to-face and often emotionally charged interactions at local mosques are being augmented, or in some cases replaced by secure online platforms designed to manage the divorce process. Imagine a couple in California, 2026. Let us call them Omar and Sarah. They are facing an irreparable breakdown of their marriage. Instead of starting with the anxiety of approaching an imam and hoping for a fair hearing, they utilize a centralized digital dispute resolution platform. This platform, developed by a consortium of legal and religious experts, guides them through the process step by step. It requires them to upload their marriage contract, input their financial assets, and complete a series of structured modules designed to facilitate reconciliation if possible, or an amicable separation if necessary. This technology serves as an equalizer. By providing a standardized, neutral, and private environment, it removes the pressure of community visibility and the potential bias of a local authority. The platform uses algorithms to identify potential points of contention, such as the distribution of a retirement account or the calculation of child support, and suggests evidence-based, equitable solutions derived from both established Sharia principles and state family law statutes. This is not about letting a machine make the decision. It is about providing the parties with the data and the framework they need to make informed, fair choices. Consider the potential outcomes of this approach. By utilizing these tools, couples can reach a preliminary agreement that is already drafted in the language of a civil settlement. When they take this agreement to a professional arbitration panel or to their attorneys, they have already cleared the primary hurdles of documentation and financial disclosure. This significantly reduces the time, cost, and emotional energy required to finalize the divorce. It allows the couple to focus their limited resources on the most challenging aspects of their transition, such as the custody of children or the restructuring of their household finances, rather than getting bogged down in the administrative nightmare of conflicting religious and civil procedures. Historical trends over the last 5 years suggest that this digital shift is particularly popular among the younger, tech-savvy generation. They are accustomed to managing their finances, their professional lives, and their personal records through digital interfaces. They view the traditional, opaque, and highly localized model of religious mediation as outdated and inefficient. They demand the same level of transparency and professional service from their religious institutions that they expect from their financial or legal advisors. This is a profound change in the culture of the community. It signifies a move away from relying on the authority of an individual to relying on the authority of a system. It is a transition from an oral tradition, where the word of the imam is the final say, to a documented tradition, where the terms of the agreement are clear, permanent, and accessible to all parties involved. This shift is essential for the long-term health of the family unit because it encourages a culture of accountability and precision. When a couple enters into a marriage under this new model, they do so with their eyes wide open, knowing exactly what their rights and responsibilities are, and exactly how any future dispute will be resolved. However, the adoption of these tools is not widespread, and it faces significant barriers. There is the issue of data security, which is paramount when dealing with the most sensitive aspects of a person's financial and private life. There is also the challenge of integrating these platforms with the existing fragmented ecosystem of mosques and arbitration councils. If a platform is not widely accepted, its utility is limited. Furthermore, there is the risk that these tools will be seen as an attempt to sanitize or over-secularize the religious experience of divorce, leading to further alienation of those who feel that the traditional, human-centered approach is the only valid way to handle such a sacred institution. Despite these hurdles, the research is compelling. Studies show that when couples have access to structured, transparent, and legally informed mediation tools, they are significantly more likely to reach a settlement that is acceptable to both parties and that is adhered to in the long term. This reduces the burden on the family court system, which is currently overwhelmed by cases where the lack of a clear religious divorce path creates an endless loop of litigation. It also provides a better outcome for children, as the parents are able to transition through the divorce process with less acrimony and a clearer understanding of their roles. What we are seeing is the birth of an American Islamic legal tech sector. This is a burgeoning field, attracting the attention of academics, lawyers, and entrepreneurs who see the potential for a truly integrated and efficient service model. The focus is on creating a system that is not only functional but also empowering, providing the parties with the education and the tools they need to take ownership of their own marital dissolution. This is the most hopeful development we have seen in our entire deep dive into this topic. It demonstrates that the community is not just reacting to the pressures of life in the United States. It is actively shaping a new model that is resilient, adaptable, and deeply grounded in its commitment to both faith and justice. The path forward will involve a delicate balance between preserving the sacred nature of the marriage contract and embracing the necessity of modern administrative practices. It will require a high level of cooperation and a willingness to step outside of the comfort zone of tradition. In the next part of this masterclass, we will move from the technological to the systemic, exploring the prospect of a national religious legal framework. We will analyze the arguments for and against the creation of a centralized, nationally recognized body that could set standards, oversee arbitration, and provide a unified voice for the community. You need to understand the implications of such a development and why it represents the final, most difficult challenge in the pursuit of a harmonious existence between faith and law. The decisions made regarding this framework will effectively determine the future of the Muslim family as an institution within the United States. The proposition of a national framework for Islamic family law in the United States is the most polarizing topic in the current academic and religious discourse as of 2026. Proponents argue that the current decentralized, patchwork system is unsustainable and fundamentally unjust. They point to the persistent cases of individuals trapped in limping marriages, the wildly inconsistent outcomes of local arbitration, and the lack of a unified voice when engaging with state legislatures. The vision is for a central, nationally recognized institution that would act as a hub for standardized Islamic divorce procedures, providing a benchmark that state courts could look to when evaluating the validity of religious contracts. Imagine a future, perhaps by 2030, where a national commission of scholars, attorneys, and family therapists exists. This commission does not hold civil power, but it sets the gold standard for practice. When a mosque anywhere in the United States facilitates a divorce, It does so using the protocols defined by this national body. This would mean that every Khul'a and every Talaq is documented with the precision required for civil recognition, including clear financial terms, child support arrangements that comply with state laws, and procedural safeguards that protect the rights of both parties. This model would transform the relationship between the Muslim community and the American legal system. Instead of the current adversarial or, at best, confused dynamic, there would be a channel for clear, structured cooperation. State courts would gain a reliable reference point, reducing the ambiguity that currently plagues these cases. Judges would have access to a repository of best practices, helping them distinguish between legitimate religious arbitration and informal, unregulated mediation. This would potentially reduce the time and expense of litigation for thousands of families every year. However, the resistance to this idea is deeply entrenched, and for good reason. The history of the American Muslim community is one of local autonomy. For many, the mosque is the center of their religious life specifically because it is independent, grassroots, and untethered from larger, potentially bureaucratic structures. There is a fear that a national body would inevitably become disconnected from the needs of local families, imposing a one-size-fits-all approach on a population that is incredibly diverse in its ethnic, cultural, and theological backgrounds. Furthermore, there is the existential concern of state entanglement. Critics argue that any attempt to create a nationally recognized Islamic body that interfaces with the civil legal system is a slippery slope. They fear it would invite increased government scrutiny and control over religious practices. The irony, they note, is that the effort to gain legal recognition for Islamic divorce might ultimately lead to the loss of religious autonomy. They ask if the price of legal certainty is the potential compromise of the very faith the institution is supposed to protect. We must also analyze the data from historical trends in other religious traditions within the United States. When other groups, such as the Jewish community or the Catholic Church, have navigated these intersections, the outcomes have been mixed. The Jewish community's experience with the get, for instance, shows the difficulty of balancing religious law with civil equality. It has resulted in decades of legal battles and a constant effort to update procedures to keep pace with changing civil norms. It serves as a reminder that this is not a problem that can be solved with a single framework. It is a dynamic, ongoing negotiation. The academic perspective is that a national framework might not be a single institution, but rather a network of standards. This could involve the creation of a national association of arbitration councils that voluntarily adopts a code of ethics and procedural rules. This would preserve the autonomy of local institutions, while providing the public with the assurance of a consistent, professional level of service. It is a model that relies on reputation and self-regulation, rather than centralized authority. This approach is gaining traction because it bridges the gap between the need for uniformity and the desire for local independence. Think about the implications of this for the average family. If a national association existed, a couple moving from New York to Texas would know exactly what to expect from their local Islamic mediation council. They would know that the standards for fairness, transparency, and legal integration were held to the same high level across the country. This reduces the risk of being caught in a jurisdiction where the local authorities have no experience in handling these matters. It creates a sense of stability and predictability that is vital for the health of the family unit. The legal and ethical questions here are profound. What happens when a national standard conflicts with a deeply held local interpretation of religious law? How do you reconcile the diversity of thought within the Muslim community, from the more traditional to the more progressive, under a single framework? Who gets to sit on the commission that sets these standards? These are not just administrative questions. They are questions of power, identity, and the very definition of what it means to be a Muslim living in the modern United States. We are currently witnessing the testing phase of these ideas. Various pilot programs are operating in major cities, attempting to integrate legal counsel with religious mediation. The data from these pilots is being collected and analyzed by social scientists and legal scholars. They are looking at the success rate of settlements, the level of participant satisfaction, and the degree to which these agreements are accepted by state courts. This empirical evidence is the foundation upon which any future national framework will be built. The pursuit of this framework is the next evolution in the story of the American Muslim family. It is an acknowledgement that the old ways of doing things are no longer sufficient to protect the rights and the dignity of the members of the community. It is a bold, challenging, and necessary endeavor. In our next session, we will shift our focus entirely to the global context. We will look at how Muslim-majority nations have attempted to resolve these exact same issues, the integration of religious and civil family law, and what lessons they offer for the American context. You need to understand that the challenges faced in the United States are not unique, but part of a global phenomenon of modernizing the Islamic family structure. We will see how different countries have tackled this, what successes they have achieved, and why their experiments in law and religion are critical for the American future. Stay with us as we look across borders to see how the rest of the world is addressing the very same questions that are defining the future of your family life. The international landscape of Islamic family law offers a compelling mirror to the challenges faced by American Muslims in 2026. While the United States struggles to reconcile a secular court system with a fragmented, private religious mediation process, many Muslim-majority nations have spent the last century formalizing their family laws, attempting to harmonize classical jurisprudence with modern legal requirements. By examining these global models, we can identify historical trends and potential outcomes that are highly relevant to the American context. In countries like Malaysia, the legal system operates on a dual track. Muslims are subject to Sharia courts for matters of family law, while non-Muslims utilize the civil system. This provides a clear state-recognized mechanism for resolving disputes, including divorce, property division, and child custody. The Malaysian experience demonstrates the benefits of having a centralized, institutionalized authority that provides predictable rules and formal due process. However, it also highlights the inherent difficulties of a bifurcated system, where civil and religious courts must constantly navigate jurisdiction, and the inevitable friction that occurs when religious interpretations evolve or clash with civil human rights standards. Consider the model in Indonesia, where the approach is more integrated. Religious courts are a formal part of the state judicial hierarchy, and their decisions are enforceable as civil court orders. This system requires that religious judges be legally trained, ensuring that Sharia rulings are consistent with the broader constitutional and civil frameworks of the nation. For the American context, this model offers a provocative possibility: the professionalization of religious arbitration. If Islamic councils in the United States were to incorporate similar requirements for legal training and judicial oversight, they could potentially bridge the gap that currently exists between their rulings and civil enforcement. Contrast this with the situation in countries like Pakistan or parts of the Middle East, where unilateral talaq remains a significant feature of the legal landscape, albeit often tempered by modern procedural requirements like mandatory registration or court notification. In these nations, the focus of reform has been on constraining the arbitrary use of unilateral divorce by imposing procedural hurdles. For example, some jurisdictions require that a divorce pronouncement be reported to a local council, which then initiates a mandatory cooling-off and reconciliation period. This is an attempt to institutionalize the Quranic preference for mediation over immediate severance. The lesson for the American community is clear: regulation does not equal the erasure of religious law. Rather, regulation is the mechanism through which religious ethics are translated into predictable, enforceable, and just outcomes in a modern state. When we look at nations like Tunisia or Morocco, which have implemented some of the most comprehensive reforms regarding women's rights in marriage and divorce, we see a focus on codification. They have taken the vast, varied body of classical fiqh and translated it into clear, statutory law that leaves less room for arbitrary interpretation and more room for judicial consistency. This is where the international experience clashes with the American reality. In the United States, the primary barrier to this kind of reform is the fear of state interference. There is a deep, historically grounded suspicion that any state-mandated codification or institutionalization of Islamic law would necessarily infringe upon the freedom of religion. Yet, the international data suggests that without this kind of formalization, the result is not greater religious freedom, but greater vulnerability for those who rely on these systems, particularly women and children. The lack of a clear, state-recognized religious legal framework in the United States leaves the most vulnerable members of the community at the mercy of informal systems that lack the power to protect them. What we are witnessing globally is a move toward what legal scholars call the constitutionalization of personal status law. This means that religious rules governing family life are increasingly being held accountable to the higher standards of constitutional rights, particularly those related to equality, property, and the protection of children. This global trend challenges the American Muslim community to consider if its own resistance to formalization is actually serving its long-term interests. Could a voluntary community-led effort to codify best practices, drawing on the successes of international models, actually provide more protection and more religious autonomy than the current, fragmented, and vulnerable system? The comparative analysis reveals that there is no perfect model. Every country is balancing its own unique mix of tradition, colonial history, legal structure, and socio-political reality. But the core challenge is universal: how to translate the ethical objectives of a religious tradition into an enforceable, just, and predictable legal reality. This is the exact same challenge that American Muslims are facing in 2026. The path to a solution will not be found in replicating any single foreign model, but in synthesizing these international lessons with the unique constraints and opportunities of the American constitutional framework. As we reach the final part of this series, we will synthesize everything we have explored over these 9 sessions. We will distill the lessons from the history, the law, the sociology, the technology, and the international models into a cohesive view of what the future could hold. We will analyze the critical milestones that the community must achieve to reach a state of legal and religious harmony. You will see why the next 5 years will be the most defining period for the institution of the American Muslim family. We are moving toward the final summary of our masterclass, and it is here that we will lay out the roadmap for how this community can navigate its most pressing legal and spiritual challenge. The journey of the American Muslim family through the landscape of civil and religious divorce is a process of maturation, adaptation, and profound legal transformation. We have seen how the collision of systems in 2026 is no longer an accidental friction, but a structured conflict that demands a systematic response. To navigate this challenge, we must synthesize the historical trends, the legal realities, and the emerging models of professionalized mediation into a coherent path forward. This masterclass has highlighted that the future of the community depends on its ability to transition from an informal, decentralized past to a formal, transparent, and legally integrated future. The first pillar of this roadmap is the standardization of the marriage contract. As we have discussed, the nikah must cease to be treated as a purely symbolic religious ceremony and must evolve into a comprehensive, legally informed instrument. In 2026, couples who view their marriage contract as a business partnership, one that clearly defines financial obligations, outlines the process for dispute resolution, and anticipates the possibility of dissolution, are far better equipped to protect their rights and their families than those who rely on vague oral agreements. This involves bringing in legal professionals who are well-versed in both state family law and Islamic jurisprudence to ensure that the contract is robust enough to survive the scrutiny of a secular court. The second pillar is the professionalization of mediation. The model of the local, untrained imam acting as the sole arbiter of complex marital disputes is becoming a relic of the past. The future lies in the expansion of multidisciplinary arbitration councils that include family attorneys, licensed therapists, and subject matter experts in Islamic law. By providing an environment that adheres to procedural fairness, transparency, and documented results, these councils provide a service that is respected by both the community and the civil justice system. This professionalization is the only way to eliminate the jurisdictional limbo that has caused so much trauma for individuals stuck in the cycle of limping marriages. The third pillar is the integration of technology. Digital-first mediation platforms represent the most promising development for the future. By using secure, structured, and data-driven systems, these platforms provide an accessible and affordable pathway to dispute resolution. They reduce the reliance on localized, informal authorities and empower couples to take control of their own divorce processes. This technological transition is not just about convenience. It is about equality, ensuring that the process of ending a marriage is governed by clear, objective, and predictable standards that are available to all, regardless of their location or their access to specialized community resources. We must also consider the role of the broader society. The American legal system is increasingly becoming more familiar with the complexities of these cases. Through the accumulation of case studies and appellate decisions, a growing body of jurisprudence is emerging that helps judges understand how to respect the First Amendment while ensuring that individuals are not denied their civil rights. This is a collaborative evolution. As the Muslim community provides more transparent and professional processes, the secular courts become more comfortable and more capable of handling these matters in a way that respects the religious integrity of the parties involved. The potential outcomes of these efforts are significant. We are moving toward a state of systemic stability where the religious and the civil can coexist without conflict. This requires a cultural shift within the community, one that values the rigorous application of law, the transparency of process, and the protection of individual rights. It requires the courage to move past the cultural baggage that has, For too long, stigmatized divorce and silenced the voices of those who have been most harmed by the lack of clear, equitable procedures. Looking ahead, the community faces the challenge of consensus. Can it establish a national framework, or at least a national network of standards, that provides the necessary uniformity and accountability? This is the central question for the next half-decade. It requires a level of collective action that the community has rarely demonstrated in the past. It demands that local institutions be willing to surrender some of their autonomy for the sake of the greater good of the community and the protection of its members. We must also continue to look outward. The global experience, particularly in nations that have successfully codified their personal status laws, provides a wealth of data and best practices that can inform the American experiment. We have seen that successful reform is not about abandoning tradition but about translating it. It is about distilling the core values of justice, equity, and compassion that define the faith and implementing them through the modern language of law and procedure. As this deep dive masterclass comes to a close, remember that the goal is not merely the efficiency of process. The goal is the health, the stability, and the dignity of the family. The legal and religious challenges we have analyzed are not abstract problems of bureaucracy. They are the fundamental conditions that shape the lives of parents, children, and spouses in the most intimate moments of their lives. The evolution of Islamic divorce in the United States is a testament to the community's resilience, its capacity for growth, and its unwavering commitment to finding its place within the American constitutional experiment. We have explored the foundations, the mechanisms, the impacts, and the future trajectories of this vital issue. You now have the knowledge and the framework to understand how this process is unfolding in real time. But the story does not end here. The landscape will continue to shift as new cases reach the courts, as technology advances, and as the community continues to find its voice. The conversation is only beginning. The critical question that remains is how the individual members of the community, those who are building their lives, their marriages, and their futures, will choose to engage with these systems. You are the participants in this historic process, and the decisions you make, the contracts you sign, and the demands you place on your institutions will determine the trajectory of the next generation of the American Muslim family. We have provided the masterclass. You are now the informed agent of your own future.